Hi, my name is Nick Mermiges. I'm a family court attorney in South Carolina. My main office is in Columbia, but I take cases statewide. And today I'm going to briefly talk about how alimony and spousal support work, and I'm going to talk about how those issues are modified as well. Okay. There are multiple different kinds of alimony that the court can award. They can award rehabilitative alimony, they can award reimbursement alimony, they can basically award some kind of, they can award lump sum alimony, and they can award sort of a temporary amount of alimony, and then they can also award what's known as permanent periodic alimony. Okay, and generally speaking, there is a kind of a presumption in favor of permanent periodic alimony in South Carolina under the right circumstances. Okay, and so what is permanent periodic alimony? Permanent periodic alimony is you basically, the supporting spouse pays a certain amount of alimony each month until the support ed spouse gets remarried or either of them dies. And there's technically also, if the support ed spouse cohabitates with someone else for a certain amount of time, that could technically terminate that alimony, but that is a very stringent requirement. If there's even a single night that they don't spend under the same roof during that time period, the clock starts over again. Okay, so that's really not even necessarily worth mentioning. Okay, because you'd have to have someone camped out at the person's house for a period of 90 days to show every single night that they're spending the night with this person. Okay, and usually when cases are that contested, someone's smart enough not to do that. Okay, now regardless, I just explained what permanent periodic alimony is. The other types of alimony, lump sum alimony would mean the court would award a certain amount, like $50,000, $100,000, and then they would make you pay it over a certain amount of time, $1,000 a month until you've paid $50,000. Okay, rehabilitative alimony would be this person needs this kind of training to get back into the job market. This is how much it's going to cost for this long, and that would just be how the court calculates sort of a finite amount of alimony. Okay, reimbursement alimony could be based on, for example, y'all had both worked and saved up $100,000, and then the supporting spouse, blew it on a failed business venture or gambled it away or something like that, and so the court can't order that money to be paid out of the bank account to the innocent spouse, and so they would order reimbursement alimony, and again it would be a lump sum, and usually it's payable in installments. Okay. And sometimes the court will award that kind of alimony if there's a concern about someone filing bankruptcy, because alimony, spousal support, and child support are given priority over other debts in bankruptcy, whereas equitable division, which is dividing assets, is not given that level of preference. Okay, so sometimes that's why that kind of alimony will be ordered. But the truth is that and courts do order those temporary or periodic or lump sum alimony payments, okay? But there needs to be sort of a specific showing justifying that. And what folks are more obviously concerned about frequently is that long-term permanent periodic alimony, okay? And there are a number of factors that the court considers when it awards permanent periodic alimony to a supported spouse. The most important factors, in my opinion, having dealt with this issue in contested cases through trial, things like that, the most important factor is going to be the length of the marriage. Okay, a brief marriage, a marriage of less than 7 years, in my opinion, it's very unlikely that a 6-year marriage would result in an order of permanent periodic alimony. In fact, for every judge is different in terms of the way they apply this law. Okay, but I think less than 10 years makes an award of permanent alimony relatively unlikely. okay? But it depends on other circumstances, okay? But that, I think the most important one is the length of the marriage. The longer the marriage is, the stronger the claim for alimony is, okay? That's sort of like the threshold to get in the door. The second issue, obviously, that's also incredibly important is that there's got to be a disparity in income, okay? If folks make almost the same income, then there's no legitimate basis most of the time for any kind of long-term alimony, okay? They will compare the paying spouse's income and the payee spouse's income, and that disparity is very important. And in fact, that disparity frequently is what they use to calculate the amount of alimony. And every judge calculates alimony differently. And also, the recent tax law changes changed the tax treatment for alimony. Alimony is no longer tax deductible to the paying spouse, okay? It is now treated like child support, which means that the person paying alimony has to report it as their gross income on their taxes, and the other person gets paid basically post-tax dollars. Up until January 1, 2019, before that, for decades, the alimony was deductible to the paying spouse, and so usually the paying spouse is the one who makes more money. They're in a higher tax bracket, and the payee spouse doesn't make much money. They're in a lower tax bracket. So by this person being able to deduct the payments, you wind up saving on taxes. This person's tax rate's only 15%. So let's say there's $2,000 a month in alimony. They only have to pay 15% on that $2,000, whereas this person might have to pay $30,000. Okay, and so basically it creates $450 that the government would normally take. Okay, that's gone. Okay, that only applies now if you're trying to modify a prior alimony award. Okay, if there's an alimony case before January 1, 2019, you can seek a modification and it'll still be, tax deductible to the paying spouse. If it's reduced, the reduced amount is still going to be deductible and taxable to the paid spouse. But otherwise, going forward now, that deductibility has been eliminated. Okay, and so there haven't been any published Supreme Court or appellate court opinions in South Carolina on permanent alimony since that change because it's so new. Okay, but basically the existing law is, and again, every judge is different. So there are some judges that don't follow this. Okay, but really the existing law is that normally the most that a court is likely to order is roughly 23 to 25% of the difference in the parties' incomes. So if one spouse makes $150, the other one makes $50, the most you can expect is about $23,000 a year, and obviously split up over months. That's the most that you can expect. That would be on a very long marriage with other factors, okay? And the change in the tax law, I think, also means that number is going to go down, okay? Because that number, that sort of, again, soft, but roughly the 24% ceiling was based on the paying spouse getting that tax benefit. Now that that's gone, maybe the ceiling is 20%, 19, 18%. Okay, we don't have any guidance, and it's not a firm rule. Okay, unfortunately, alimony is not like an algebra formula where you can just plug things in and get a predictable answer. Every judge has sort of a different view of things, although many of them subscribe to what I just explained, which is that it's called the Dickert case, that limits the amount that you're supposed to pay. Okay, but every case is different, and there are a lot of other factors to consider. Okay, so knowing that there is this sort of soft ceiling, the other factors that a court's going to obviously consider are going to be beyond. I've already talked about length of the marriage is sort of the very most important. The disparity in income is also, it's equally important. Okay, I mean, if it's a long enough marriage that it makes sense for permanent alimony, there's got to be a disparity in income for it to be ordered. Okay, then you got to look at the health and the earning capacity of the parties. Okay, so if one spouse is deliberately underemployed, refuses to work, has a work history, but just doesn't want to work, you can actually potentially get the court to impute income onto that spouse based on their past earning record, or you could even hire an expert to testify about how much that person could earn if they were actually trying to work. Okay, So earning capacity, and that's obviously also based on educational background, work history, things like that. Okay, and then at the same time, health. Okay, if somebody gets cancer during a marriage, if somebody has an illness during a marriage, if something happens during a marriage that makes it so that somebody is no longer employable, or that can't work full time anymore, or they go on disability or something like that, that's going to be considered by the court in its alimony award, because it impacts that person's ability to earn future income. Okay, so a spouse with an illness is going to have a stronger entitlement to a larger amount of alimony potentially than an able-bodied spouse. Okay. The next factor that really matters is what other money is out there, the size of the marital estate. Okay, and what other access to income does each spouse have? So if you have a spouse that doesn't work, but they have a trust fund that is about to kick in, or they inherited a house with no debt, then that their expenses are going to be less, so the amount that would be ordered should be proportionally reduced. Okay, or if there's a lot of money saved up, if there's $1 million in investments on a very long marriage, that spouse gets half of those funds. Okay, then that would assist in providing for them. So ordering alimony on top of that might not be appropriate, or the award should certainly be less. Okay, beyond that, likewise, if folks retire, if there's a retirement, the retirement payment might be just divided. If there's a pension and it was all earned during the marriage, that might be split in half. And I mean, if that's the source of income for the paying spouse, and the payor spouse gets half of it, then it probably doesn't make sense to order any alimony on top of that. Okay, and then the final, it's not the final factor, but in my opinion, the final very important factor is fault. Okay, if the paying spouse steps out on the marriage and leaves, that's going to be considered by the court in its alimony award. Okay, alimony is not supposed to be a punishment. And it's not, it's not going to be a punishment, but the court is going to consider the fact that if there's a long-term marriage, and somebody is at fault for the breakup of the marriage, that's just going to be a factor that's considered in how much is awarded. And of course, if adultery is a bar to alimony, if one spouse commits adultery, they can't turn around and seek alimony from the person that they just cheated on. Okay, so that goes both ways, and it's considered both ways. And then sort of the final thing, which I sort of already addressed, which is work history, is if the supported spouse specifically gave up opportunities during the marriage, whether it's to care for the kids or moved around because the main earning spouse's job forced them to move around, or worked for a business that was owned by the spouse, those kind of things, those are going to be considered in an award of alimony. Okay, so all those factors. That's a non-exhaustive list, and in some cases, different factors become more important. Okay, but those are kind of the key factors that a court is going to consider when awarding alimony. And as I said, there's not one formula. Okay, ultimately, it comes down to need. What was this person's lifestyle? How much money does it take to maintain that lifestyle? What's the difference in their incomes? How much money is there, and even if they can't maintain their lifestyle, how much does this person need to have a dignified life after this relationship ends? Okay, and whose fault is it that the relationship is ending? Okay, so those factors are all considered, and the court will make its decision based on that. Okay, and as I said, there's not some fixed rule, there's not some fixed ceiling. And every case is a little bit different. In particular, a lot of alimony cases, they go to trial, and so the judge gets really a look at people. People testify, they're cross-examined, they're character witnesses, a private investigator might be called to testify about what's going on, and the court really gets a sense of what these people need and considers, who's being truthful and who's exaggerating, and ultimately it issues its final ruling based on all those things and the impression that it gets. Okay, but when you're trying to settle an alimony case, knowing what factors come into play are very important. Okay, and that can help you kind of think about what a judge might do, because the goal ideally is to get a good outcome, a fair outcome, and to be informed by what a judge might do, what the ceiling might be, and then to not have to waste tens of thousands of dollars on trying a case over this issue. Okay, so that's generally how the process of alimony is considered or awarded in South Carolina. As far as modifications, alimony can be modified based on a change of circumstances. The most significant change of circumstances would be if the paying spouse, loses their job. If the paying spouse is laid off from their job, you can hire an attorney to get in there and get a temporary order. Basically, let's say someone gets laid off, they hire an attorney. Hopefully within 30 or 45 days, that attorney will get a temporary court hearing. And at that court hearing, as long as it's not somebody's fault that they were let go, if it's downsizing or, whatever else, as opposed to voluntarily quitting, right? Or even being fired for some kind of misconduct, that's sort of more of a gray area, okay? But if it's a layoff, it's which happens routinely, especially to older workers, okay? Change of boss, things like that, things that are beyond your control, the court will very frequently give that person relief from their permanent alimony and will permanent periodic alimony and will modify the order on a temporary basis. Doesn't mean that it'll be eliminated, but it may be cut in half. If your income's cut in half, maybe your alimony obligation will be temporarily cut in half, okay? And then basically you will litigate that modification case until there's a determination about what changes occurred, okay? And if you have to, you go to trial on that, all right? And beyond being laid off, obviously if you've got a commission job and you just have a bad couple years, or the nature of your industry changes, if your earnings go down through no fault of your own, you have a credible claim for a modification, okay? And retiring at a certain point, everyone's entitled to retire. You're not required to keep working past your retirement age to pay an alimony award. If you're going to retire and you have a permanent periodic alimony award still being paid, and retirement is obviously going to reduce your income, you have a credible claim to seek a modification, okay? And then to some degree also, and disability would apply too, okay? If you're disabled and you can no longer work, obviously that would be a credible modification claim. And then, of course, if the supported spouse, because alimony awards almost never, when people get divorced, it's a financial hit for everybody, period. There's no getting around it. Alimony awards almost never make it so that the supported spouse doesn't have to work, or at least, they almost never make it so that the supported spouse doesn't have to work and enjoys even remotely the same lifestyle they enjoyed while married, okay? That's almost never happens. So usually the supported spouse does work, or at least, or they remarry, and if they remarry, the obligation terminates, right? But if the supported spouse's income significantly increases, I think that you can also credibly seek a modification under those circumstances, okay? So that would also justify a modification, all right? And so that's generally how alimony modifications work, and child support modifications, and the change in relative income. As long as it's not done to try to game the system, and it's more than 5-10%, if it's a significant change in income, you're very likely to get relief and to get justice, okay? And obviously when you're on the front end, if you're dealing with a case where there's not an award set yet, you may want to think about retirement and say, unless there's a disability, this person will retire at 65, and when that happens, the obligation's going to go down to this, okay? You can hopefully, if you're trying to negotiate a case like this, you can plan it out in a way that is informed, that avoids the need to hire a lawyer a second time to get a modification. That you can't always do that. You can't do that in every case. but you at least want to have an attorney who thinks about that and tries to do that, because the goal here is not to spend all your money litigating unless you have to, unless you have no choice because the other person's just not being reasonable and you have to make a judge decide. Okay, so those are some of the issues that are considered in an alimony award. Our firm handles, divorce cases with alimony components all the time, as well as modification cases all the time. If you have a case like that, or you'd like a free consultation, you can always give us a call at 803-724-1258. We'd be happy to speak with you and see if it's something that we can help with. Again, this is, it's been a non-exhaustive list, but it gives you a sense of how courts think about these things in my experience and how these claims are handled. So thank you for your time. I hope it was informative.